Welcome to Trust GBS. In each episode, we'll get together with other professionals and have fun talking about trust and estate matters. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, lawgbs.com. Now here are the hosts of Trust GBS, Lori Bolander and Lauren Gallagher.
Hello, I'm Lori Bolander.
And I'm Lauren Gallagher.
Welcome to Trust GBS, where we explore the practical, legal, and human sides of trust and estate planning. Today, we're diving into a topic that often overlaps with trust and estates, but doesn't always get a lot of attention: family law and divorce. Estate planning and family law intersect in more ways than many people realize. We deal with it a lot. From updating estate plans after divorce, beneficiary designations, trust issues, separate and community property concerns, and planning for blended families. So we're excited to welcome our guest today, Frann Setzer, family law attorney with extensive experience helping clients navigate some of life's most significant transitions. Frann works with individuals and families on issues involving divorce, custody, support, property division, and related family law matters. We're going to talk about some of these crossover issues that happen between family law and trust and estates. Some of the mistakes people make and practical steps people can take to better protect themselves and their families. So, Frann, thanks for joining us so much today.
Thank you both for inviting me, Lori and Lauren. I'm happy to be here.
Yes, we're happy to have you. So I thought we could start with just having you explain what is family law and what kind of matters fall under that umbrella. I mentioned, a few of them, but I think a lot of people are unclear. I'm sure you get referred to as a divorce attorney all the time.
I do. And of course, that is a part of the practice. We do help people through what we call the dissolution process, which is basically divorce. We also will do legal separations if there's something called a nullity, which means that a marriage would be found to not have existed at all. But the divorce umbrella is encompassing in that it's property division, which can be anything from dividing a business, real estate, etc., to custody of children, minor children, to spousal support, to child support, anything that really has to do with your marriage or your wanting to be legally separated or having a domestic partnership.
So I know we've seen types of different clients for types of different matters, but one of the things that I've sent a lot of people to for are premarital agreements, prenuptial agreements, sometimes even postmarital agreements. And there are some crossovers just in that whole process too of the premarital, postmarital agreement as far as estate planning goes.
There is extensive overlap. Just what I try to really say to people in a lot of occasions is that estate and family law are kind of two sides of the same coin. One is often what happens with your property upon death, and one upon divorce. Premarital agreements, I should probably have included that in my practice, as they are much, much more popular. I'd say in the last 5 years, I've had a tenfold increase in the number of premarital agreements. Yes.
Well, that's good.
It is. It's really interesting as well. By and large, most of the people are older, second marriages that want to essentially preserve their assets. And in some of those situations where the people are a bit older, there is the family component in terms of estate planning. That in these second marriages, a lot of times their children are very concerned about the new spouse. And what will the new spouse be getting, quote unquote. But there's also a fair amount of younger people who already have some assets. Sometimes in California, you'd be surprised the number of young people who have a fair amount of assets.
Yeah, that's true.
Yeah. I'm sure you've had that biotechs. They're 30-year-olds and they're millionaires. So people with substantial assets that want to protect them. Or what's very common is that we will have parents of children who are somewhere between 25 and 35, or grandparents who know that they're going to be inheriting a lot of money. And so prior to marriage, they would like those things addressed as well.
Yeah. Do you ever do agreements, or do you suggest people do agreements when maybe they don't have a lot of assets, but they want to just get the kind of the rules down as to what will happen at the time that they do have more assets?
Yes, very often we do those kind of agreements because people are anticipating an event down the road.
Mm-hmm.
They do know that something is going to happen, either inheritance, or they own a business right now that they think is going to be very successful, etc. So we do find that there are a lot of people doing premarital planning, for lack of a
Mm-hmm.
better word. In premarital agreements, you can also put some limits on things like spousal support. So we do have a lot of people wanting to address that, just to know their future. If
Mm-hmm.
someone knows they're going to be the earner, they want to have brackets about what their future might look like financially.
And are those enforceable?
There's always a second look that goes into spousal support. Yes, they are enforceable, but a court would look at what is happening at the time of enforcement to see if it is enforceable. I routinely would advise clients who think that they will have a lot of money and their partner may not, to put some sort of support provision versus a waiver, because a
Mm-hmm.
waiver is where you're most vulnerable. If in 10 years you have $10 million and the other person would get nothing. So you want to make provision, in my opinion, for some sort of spousal support. Now, let me also say that things such as child custody and child support cannot be included in a premarital agreement by law. So if people have children, that is just going to be by law, whatever a court would decide child support or child custody would be.
Mm-hmm.
Yeah.
That makes sense. I
Yeah.
think there's also a rule around premarital agreements, as far as like when the agreement is presented to the spouse. This is something that most people do not know, and that they both have to be represented. Isn't that correct?
They do have to be represented. I've had people not represented. Can those be enforceable? Yes. But if they're very inequitable, you'll have a hard time with validity. I think that a court would probably see some sort of influence happening prior, if there isn't representation.
And what didn't that go back to, like Barry Bonds or something?
Yeah, it did. That was one of those, his agent came up to Sunny, the wife, on the courthouse steps when they were going in to get married, saying, sign this, after he had just signed some sort of like big, $3 million deal or something like that. So that actually is why those laws came into effect, because of
and it has to be presented 7 days before marriage.
Yes.
Right?
So one of the things, and I guess attorneys are different. I get so many calls from people a month before marriage saying, hey, I'm getting married, let's say June 15th, and I need a premarital agreement. I do not take clients less than 3 months prior to their wedding.
Yeah.
That makes sense.
Yeah, because there's a lot of question around the rush, right? The courthouse steps, so to speak, even if it's not literally the courthouse steps. Just making sure that everybody is represented, everybody understands fully what the agreement says, what the agreement could say, what the default law is. It's just, if you want this to stick, there needs to be time put into the process. And yes, it has to be presented 7 days. You get 7 days, a cooling off period that you'd call it, 7 days to think about it, then it can be signed.
So
and we try not to do that too close to the wedding also.
Right.
What I see a lot is clients come in, it's a second marriage, they don't have a prenup, it's messy, and they want to do estate planning. And that always makes me anxious, because clearly they have not taken the appropriate steps to determine between the two of them whose is what, right? And who it belongs to, so I can help them plan for who it's going to go to in the end. And so that, to me, would merit a postmarital agreement. So is there a big difference between the premarital and the postmarital? Like, are the rules different? How does that work?
Yes, there is a huge difference in our world between a postmarital agreement and a premarital agreement. While it might sound funny to the average person, because most people who are going to get married are living together, are very involved with each other, that marital event immediately kicks in what we call the fiduciary duties of marriage. And as soon as you get married, you have a lot more rights. So the financial disclosure process, which is whether it's a premarital or postmarital agreement, there is a financial disclosure process. But the postmarital agreement financial disclosure process is much, much, much more extensive, because usually a postmarital agreement, for example, you have your premarital assets, and usually most postmarital agreements either want to transmute or go back and preserve and say, hey, we missed our deadline. We still want to have our separate property. Well, you've got to do accountings for from the date of marriage to whenever you get around to this postmarital agreement. What did you have at date of marriage? What's the growth been? What have you taken and saved? So there has to be disclosure. It's fairly extensive. And
I did not realize that.
I didn't realize that either. Yeah, I just
Yeah.
figure they could agree at any point to anything.
No, and especially if you're going to do something like a transmute, well, you can agree. It's just that if you don't have the proper disclosure, it's going to get thrown out. That's the
Yeah.
number one reason that post and premarital agreements get thrown out, is inadequate financial disclosure.
Oh,
Interesting.
yeah.
You mentioned the word transmutation and, separate and community property, and I wanted to touch on that. That's something that we deal with a lot, and I wanted to just have you kind of go over what's separate, what's community, and what is a transmutation.
Yeah. So separate property, in essence, is anything that you have accumulated prior to marriage, during the marriage. It could be via some sort of inheritance or bequest, or anything after your date of separation, which is a little bit different topic of what is your date of separation, but anything after your date of separation. And it can get a little complicated, a date of separation. For example, I just did a marriage, a dissolution, where the people have been separated 7 years. So there was a lot of post-separation assets, debts, etc., which gets a little bit complicated. So, but the community ended 7 years ago, right? So transmutation is a little bit, so that's your separate property. Community property is any debts or assets that you've accumulated from your date of marriage to your date of separation. And that's your community. And if you would go forward with a divorce or legal separation, that is what gets divided. That is part of your community estate. Now, a transmutation is our language for changing the character of your separate or your community property. And it can go from separate to separate. It can go from community to separate. And that's probably something that both of you have dealt with extensively when you do estate plans for people who have separate property. And suddenly they say, well, if I pass away, I want this to happen. But they don't always give thought to, will I want this person to have this house that I inherited if I get divorced?
Yeah.
Right.
So that's always an issue, and it's complicated because there's
the other reason that it's complicated for us in the estate planning world is when your spouse dies, you want things to be community property for the step up in basis for capital gains.
Right.
So we just added a whole bunch of language to a lot of our forms about, we're only going to advise you as a separate and community property as it relates to estate planning. We're not going to advise you on what happens if you get divorced, and you should contact a family law attorney, because that can be a big problem. I know there was 5 or 6 years ago, there was an attorney that just put everything's community property in the trust, and then they got divorced and it caused a huge problem in the divorce. I think the client sued the estate planning attorney because it was
Yeah, that wouldn't surprise me, because we do run across that. And, I'll be honest, we get that and we go, oh no,
Yeah.
what are we going to do? I've got a document that says something is community property. And if there is a marital agreement or a formal transmutation agreement within that estate plan, the case law, it's very, very clear. There's no condition or no going back. You don't do that type of a transfer of property and say, oh, it only mattered if I died. No.
They always ask that. Well, can I have it be community property if I die, but if I get divorced, it's not? Nope.
No.
All or nothing.
It's all or nothing. The law is really crystal clear about that. And the transmutation agreements that are done, and marital agreements will often have transmutation agreements within them, because you're married for a while and sometimes you're transmuting certain of that property since your marriage or not. But transmutation agreements are really very particular. There's a lot of case law around them. They're very, very fact specific. They require a writing, so it can't just be an oral, oh, you promised me XYZ. There has to be some sort of a writing. And a deed, for example, you could go in and change a deed. That by law is considered a writing. Other kinds of writings have to pass a little more muster of when they were made. There's a presumption of what we call undue influence within a marriage, that if you're married and are giving somebody something, there is some sort of undue influence. And there's really a lot of hoops to jump through to prove that if something is separate to community or community to separate, that it is done without what I'll define as undue influence.
Yeah. Well, that's a term, as you probably know, in trusts and estates,
Yes.
for elderly people being unduly influenced in their estate planning. So we're familiar with that one.
Elderly people and people in love.
Right. It's true, though. I've seen some clients do some real silly things.
Yes.
When they're in love. Yeah.
Same here.
Yeah. One of the things that I'm also always encouraging people to do is to actually do estate planning if they're getting a divorce during the divorce.
Yes.
Because sometimes, they'll say, oh, I'm going to wait till this is all done and then I'll do it. But there are some things you can't do during a divorce.
Right.
And so there's, what are they? The automatic restraining orders.
Yeah. ATROs, automatic temporary restraining orders. Yeah. So as part of my practice, I will routinely ask someone if they have an estate plan and advise them accordingly. Most estate plans, if people have it, as I know, I don't need to tell you, there's the will, there's the trust, there's the healthcare directive, and there's the power of attorney. Now, of course, I tell people a power of attorney and a healthcare directive that can be changed immediately. There's no restraint or law that says you can't do that. And of course, I encourage all of my clients to draw up new healthcare directives and new powers of attorney immediately. With the caveat of, do you want your ex or soon to be ex in charge of pulling the plug? Because right? That may be the case.
Or deciding what medications you're going to be given.
Right. All that. So that can certainly be changed immediately, along with a will. That can be changed as well. A trust, not so much. You can revoke a trust. So if somebody has a trust, depending on their circumstances, I will say that they should revoke. Because I think that we haven't really talked about it, but if someone does pass away during a divorce, that creates a little bit different issue. And depending on their assets and their circumstance, they may need to revoke the trust. That may be their better bet than not. But
for a joint trust, they're doing it together. So there is an argument that it benefits both parties to revoke the trust, right? Because neither one would want the other one to inherit from the other. Well,
Depends on the circumstance.
Right. But, you're right. But there are the ones that I've seen, it's like, well, go talk to your divorce attorney because you might be able to convince the other party that you both should revoke it.
Right.
But you need that guidance from your divorce attorney, not from us. Get the green light first.
Right. Because there are certain circumstances where I'm like, no, don't revoke. This could work out really well for you. I know this is why people hate attorneys. This could work out really well for you. But there are other times where I say, no, you want to be sure to revoke that trust. And usually, gosh, I think I've only seen one or two trusts that require both parties to agree on a revocation. Most allow revocation that I've seen anyway by one party. I mean, the method is usually spelled out, whether it's personal revocation or however. It's always in writing.
Yeah, usually it'll be you can revoke it as to your portion of the community property and your separate property. Yeah.
Right. But of course, then if someone does pass away, then maybe you're in probate. But then again, that might be a better option versus letting somebody inherit. Again, depending on the circumstances.
Yeah. Well, I've definitely seen estates where it's gone to the estranged spouse, or at least, mostly, and the family is just, up in arms about it. But it's like they didn't do anything, So
Right.
So what happens if somebody does die in the middle of a divorce?
So it gets punted to you all is what happens if the marriage is not terminated. Family court only has jurisdiction as long as there's a marriage. If someone passes away during the marriage, there is no marriage anymore. So it goes over to, the estate planners to probate court. Now, there are circumstances where I will tell people that they need to do what's called a bifurcation, which means that if there's a lot of different assets, what we do is we get people divorced first, which means that you can be unmarried and then settle your property or your custody or your support a little bit later. Of course, in California, you can do that. The earliest you can do that is 6 months from when the person is served with a petition for dissolution. So there's a little bit of a time lag on that. If there's a bifurcation of status, the family court will retain jurisdiction of all of those issues.
Oh, interesting.
Yeah. In the probate world, if they're not divorced, right, and they die, then they qualify as the surviving spouse under the probate code definition. So which is why I always look at assets.
I always look at people's estate plans when they have substantial assets. Not that just weird things happen. I mean, 95% of cases, no weird things, but sometimes if they're older, especially, or people are sometimes ill, you want to look at those things. They're kind of red flags for a family attorney to take a look at the estate plan. It's important. I will say, I also tell my people, my clients, to start working on their trust. So they can redo their will, they can redo their advance directive, they can redo their power of attorney. And then I want that trust set up so that as soon as we've got judgment, we are putting assets in.
Right. Because the main point of the restraining order is to keep people from moving assets.
Correct.
So it's logical that you can do all these estate planning documents. You just can't start moving the assets around.
Right. If they're in the name of the trust. Right. And it's the same in our world. You can't change beneficiaries. You can't be like, I'm getting divorced, so my retirement's not going to you, or my life insurance isn't going. You can't do any of that. That doesn't necessarily affect you because those are outside of really what you do. But that is the entire point. So they don't want trusts funded, with your half of things immediately. But I do like things to be set up so that there's just not a time lag, because it takes time to draw up those documents.
True.
Yeah, definitely. What's one thing you wish all the estate planning attorneys would discuss with their clients?
Well, I think that you sort of mentioned it, which is it's difficult to get those estate plans that have transmuted property. So I just wish that you would, and you guys do it, but that, estate attorneys would really talk about their clients. And granted, it's uncomfortable to talk about if you die, but I think it's also kind of behooves you to say, hey, what if you get divorced? You should know the rules are different. And I'm not saying necessarily you would advise them on that. I know I don't advise anyone on estate planning, but just to let them know that their plans right now might not be the best plans if the marriage ends.
Yeah. Well, and we have to talk to them about so many uncomfortable things. I mean, so many people are uncomfortable about death, but then it is weird to have to be like, okay, happy couple, what if you get divorced? It's never going to happen,
Yeah.
And it doesn't 50 or so % of the time. But again.
Well, and it's funny when I hear people say like, I'm never going to get divorced. And it's like, but you may not have a choice. It might not be you.
Right. And it's not. I mean, in most cases, both people are not always on the same page.
Yeah.
If both folks are on the same page, I don't want to say it's easy, but it's fairly easy. It's pretty unusual that both people are kind of right there at the same time.
Yeah. I feel like somebody's usually shocked or blindsided.
Yes. I've few of those recently.
Yeah.
Yeah.
Mm-hmm.
Yeah. That's not unusual.
Yeah. And, same thing when somebody passes away, sometimes people are shocked and blindsided because it wasn't expected.
Right.
So we deal with that. We also deal with when we're planning and, mom and dad are saying, we're going to give everything to our 2 kids, but we really hate our son-in-law. Is this can my daughter keep it separate, And it's like, yeah, but once it goes to her, she can transmute it. So I'm always telling our clients, like, we'll talk to them about that. And then I've had a few clients that have wanted me to put in a whole clause about, it's not actually distributed to the child. They have to go set up a separate property trust. And then the inheritance is distributed into a separate property trust. I'm like, I mean, they can take it right out, but at least
that doesn't protect them in my world.
No, it doesn't. But I guess at least it starts out in the right place. If they take it out and commingle it, then we did our best, right?
Yeah. So there are actually people that come to me for premarital agreements, and I will say when it's largely inherited type funds, I will say I can do a premarital agreement, but I'm not sure you need a premarital agreement. What you need is counseling on what to do with your separate property.
Yeah. Keep it separate.
Yeah. And people are like, I'm not sure what that really means, because we want to take that vacation to Tahiti.
Right. Or we want to buy a house. We want to, we're going to use it to put a down payment on this house. And it's like, okay, go get all that in writing that you're using your separate property to buy this community property home and preserve your separate property. I'm not going to do that for you. Go talk to Frann.
Right. That's what I would do for you. But even in those circumstances, so there's a difference between, well, are you buying a home in your name with your separate property? Or are you putting a down payment on a community home?
Right.
And the rules and reimbursements and it's all different depending on the circumstances.
And that's one of the things that you can dictate in your premarital agreement too, is how that all works. Yeah. That's where I feel like
in California with the property value so high and the mortgage underwriting, like they need both spouses' income, even if really the intent isn't that the one spouse is supposed to be the owner. They end up, Lori and I see this all the time with our clients, like, oh, we're both on title. Oh, you're both on title. Oh, really? Why is he on title? He wasn't supposed to be on title. But in the process of borrowing, that all happened. And they don't really think through it that now husband or wife is on title and an owner of something they really didn't intend them to be an owner of. It's just for financing purposes.
Yeah. happens all the time with parents and children too,
Yeah.
Yes.
because sometimes they need a cosigner, and now all of a sudden, the half the family is entitled to this property, and they're like, but it's ours. And we're like, but it's not.
Right. Now we have property tax issues too.
Right.
Yes.
Yeah, in our world, those are somewhat messy situations, right? There's case law, of course, that talks about intent of the lender that Lauren, you were referencing when you're getting a loan. In premarital agreements, we will often work around that. Case is called Grinius, and we'll often work around that and say, hey, we understand Grinius, and we purposefully, there's all this language talking about why that will not apply, depending on the,
Interesting.
Yeah, that's good to know.
depending on the circumstances.
Yeah, one of the things I've seen more and more are couples that they own a house together, they have children together, and they are not married.
Yep, same. And
Yeah.
zero plans to get married.
Yeah, no plans to get married.
None.
So, I mean, do you see those situations? I mean, because obviously it's going to be similar to a divorce if they separate, because they have to deal with the custody and the assets and all the things. They just don't have a marriage.
Well, so we deal with part of that. We deal with anything that has to do with minor children. So we would deal with custody and child support. If there is no marriage, you're not going to, you'll be in a parentage case, right? Because if you've had children together, but you won't be in a full, any kind of dissolution case, because as far as the law is concerned, there's no marriage.
Yeah.
So what's going to apply is as if you were two third parties that maybe own a house. It's a third party situation. Any kind of basic real estate law, contract law is going to apply. You don't have what are really the protections of the family court. And family court really does favor marriage and really does favor giving spouses as equal access to assets, debts, etc., as much as possible. So you're in a little different situation. If you want to, if a spouse was, let's say, one of the people that you're talking about was a stay-at-home spouse, and let's say all the assets were in the owner's name, the earning spouse's name, and that could be the woman or the man. You're walking away with no property.
Yeah.
You don't have rights to spousal support. There is, of course, the case, Marvin v. Marvin that we talked about, known as palimony, from the actor Lee Marvin, where you can go to try to get what is essentially spousal support in civil court. It's called quantum meruit. It means payment for services rendered during the marriage. And that can be, anything from, if your husband, let's say it's a husband was an executive, and you entertained and you cleaned and you put together the parties and you raised the kids, what would be the costs for having to hire someone to do that? That's essentially what it is. And that's kind of payment.
And how high is that bar?
It's not easy.
I was going to ask that too.
Yeah.
And would you handle that type of a case? Because it's in civil court.
Yeah, it's in civil court. I don't do Marvin actions. I do pair when there's minor children. I pair with a civil attorney and I handle the family part, and the other person will handle the civil action.
Interesting.
Yeah, I've heard people have brought that case up to me. We get on the internet, I'm sure, a few times, or I get a call, well, I'm his common law wife, and people don't understand that that's not a thing in California.
In most states, it's not a thing.
Right. I don't even know how many states. It's very few.
It's less than 10. I don't remember exactly, but very few states have common law marriage.
But yeah, I don't think people realize the complication. I think that one of the reasons they don't get married is so that they can just, quote unquote, walk away if it doesn't work out. Right. But that's not really what happens, I'm sure. Well, not with kids in a house and all that,
right. Or it may work out for someone.
Yeah.
One of them, but the other person is going to be not happy.
Now, sorry, I'm interrupting, but can we segue to domestic partnerships? Because I think our clients, and I think most people who have them, are misguided about what they are, how they get out of it, if they want to get out of it, and what it does.
So
Yeah, go ahead.
the modern day domestic partnership is very similar to a marriage now.
Now,
Um,
why would you enter into a domestic partnership instead of a marriage? Because you've got a hang up about marriage, your parents had a messy divorce, so you're like, I'm never going to get married, but I'll go into a domestic partnership. Or is it for insurance purposes? I mean, why do people do it?
all of the above.
Mm.
I don't do a lot of domestic partnerships. Obviously, there were more of them when you couldn't. There was same sex marriage. There were more of them. Um, Now, health insurance is maybe one reason why people do that, but a lot of companies don't even ask for a domestic partnership. Some do. Some say, "Hey, are you living together? Is this your significant?" That's enough. If it's your significant
Yeah,
other.
I've seen
And
that with clients. Like, oh, I don't know, my partner's insurance or company let me be his. I'm
yeah,
like, but did you file something with the state? Like, are you a
mhm.
registered domestic partner, or are you just calling yourself a domestic partner? I assume there's a distinction.
Oh, well, there is, because if you have a registered domestic partner gives you certain rights similar to a marriage. Calling yourself one, you're in the situation that Lori talked about, which is, hey, we're just together, and third
Mhm.
parties together. And maybe you can get health insurance. I've heard of quite a few companies just saying, sure, you live together, you say this person's your significant other, sure, we'll cover them. And you're not a registered domestic partner. That requires paperwork. And if you want to
Mhm.
dissolve it, similarly, it requires paperwork.
It's almost like a full divorce, right? I mean, you file a petition for a dissolution of your domestic partnership. I don't think
Correct.
people understand that.
Correct. It is. But it gives you the protections, right? If you do the whole legal relationship, you get the legal protections.
Right.
Yeah.
Otherwise, you don't. And
Yeah.
that could be sad,
Yeah.
for people that are together 30 years and it's 60 something years old, just
Yeah.
aren't entitled to anything.
I have quite a few clients who have been together for decades and are just staunchly not going to be married. And the biggest issue is property taxes.
Right.
If they co-own the property, that's one thing and live in it, the property. But if it's, rental property, there's a reassessment.
Right.
Mm-hmm.
Yeah, there
Yeah.
is.
I've had the opposite too, where my clients were married for 30 years and now they've been separated for 15 or 20, but they're
Not going to
living
be.
in separate areas of the county and they're not divorced. They still have a joint trust and they come in together and it's very contentious. It's very weird, but
Yeah.
they just aren't going to get divorced. So
Yeah. Yeah. And I like I said, that case I mentioned, I just finished after 7 years.
yeah,
Uh, Boy, there's a lot that happens in 7 years to untangle.
yeah, I can imagine.
Yeah.
Yeah. Yeah. Unless they're both on the same page.
Yeah.
But
But as we know, that is not
the
always how
same,
things work out.
well, same page, but somehow they're reading things differently.
Right.
A
Right.
little
Different
different
languages.
interpretation.
I have a few who are amicably
Yeah.
unwinding their marriage, which is surprising to me that there's as many as I've seen come
Yeah.
across my.
I've seen a lot,
Yeah, that's great
but
Yeah.
because
I
nobody
have
really
too.
wins.
No, I have too. And I've had plenty of people come to me that I kind of never see again, but just for advice on how to do that.
Mhm.
And,
mhm,
what would happen if they got a divorce versus lived in a certain way, right? And kept certain benefits.
hmm,
And there are times, especially with older people, where I'm like, don't get divorced.
Right,
Why do you want to half your estate at
right.
this point in time?
Yeah,
especially if they're going to leave it all to their joint children or something like that
right.
too,
Right.
you
Yeah.
know?
Yeah. No,
Yeah.
that's absolutely the case, and I've done quite a few. You maybe hate these, but I've started to do quite a few marital settlement agreements where people agree to leave some of their long-term marriages. They've accumulated a lot of assets after 30, 35 years, and they both agree to do estate plans to leave their shares to their kids. And
Mhm.
I don't know, you probably hate
I
that.
I have dealt with a few of those, yeah.
I don't know if
And
I'd hate that. Are they enforceable at death?
Yeah.
Well, they have to drop an estate plan that says that. Now, there's a breach, where you draw it up so that if someone doesn't do that, it literally says you can sue the estate.
Yeah. And I've done it, and it's interesting because we have this strange sentence that we put in our wills that says, I have not entered a contract to make a will. And when I have had to deal with these, I have to remove that. And then I actually just reference it. I'm like, I have entered a contract, because that's what a marital settlement agreement is. So I just say, I have entered a contract to make a will, and it's dated, this is the name of the agreement and the name that it was signed or date it was signed. And yeah, it's kind of interesting because I think there's a lot of that in marital settlement agreements about life insurance too.
Yes.
I've gotten that call of he was supposed to name me beneficiary of life insurance and he didn't. And that's a civil court thing too,
that is.
Right? Because that's a contract with the company that he signed.
Yes.
So
yeah, that absolutely is. If someone just doesn't follow through, it's a breach of contract, essentially. But that's good for me to know in a will that there's that line in there about not entering into a contract. And I will tuck that away in those cases.
Because the client's never going to know or notice, No. We were just talking today about how they probably don't even read the letters that we send them with all this great information that they should have. But
right.
and a lot of them don't read their own estate planning documents.
No,
and it's just kind of one of those standard lines that's in there, and it needs to be changed if you have in fact entered a contract to make a will.
Well, that's good for me to know, because I'm actually in the middle of doing a settlement agreement for folks that are doing just that. They have rental properties that are, big commercial properties they have agreed to leave to their kids in their estate plans. So I'm going to add that to tell them that when they redo their estate plan, make sure the will says, yes, I've entered into a contract.
Yeah. Well, I think we've taken enough of your time today, but this has been so interesting. And, it's just an area that we have a lot of crossover with the estate planning world, with the post-death world. So we thought it would be great to have you on to tell us more about all of it. I always learn something when we talk about these kinds of topics where we have these crossovers, So
yeah, same here.
So those that are watching, you can contact Frann at setzerfamilylaw.com. And thank you for tuning in today and joining us on TRUST GBS. And you can visit our website at lawgbs.com to learn more about us and the attorneys at our firm. Thank you again, Frann, for joining us.
Frann.
Thank you both. Good seeing you both.
You
too.
Okay.
You've been tuning in to TRUST GBS with your hosts, Lori Bolander and Lauren Gallagher. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, lawgbs.com. Thank you for your positive feedback, comments, questions, and sharing this show with others.